Okay, welcome back everybody, and welcome to week 6 of 7 of mini law school. Being that we're at week 6 of 7, and because I'm starting to get a lot of questions about it, I just wanted to quickly go over your certificates of completion with you and explain to you how that works. If you have completed, when you show up next week, if you've completed 5 of the 7 modules, or at least 5 of the 7, you'll receive a certificate of completion. We're going to hand those out at the door here in Boulder. For those of you taking the class at CU South Denver, the certificates will be there at the door. And those of you that are doing the recorded viewing, those are the only certificates that I'm mailing to people. So, you ask, I'm not going to be here next week. How do I get my certificate? If you're taking in Boulder, the certificates will be available in the dean's office in Boulder until January 1st. So you've got a whole bunch of time to either make up your missed classes if you're missing some, or just to come and pick your certificate up if you can't be here next week. But again, those of you that are going to be here next week will just get yours at the door. CU South Denver, exact same thing. Any certificates that are not picked up at CU South Denver next week will remain at the student services desk, and you can pick them up from Paul, who's been checking you in at CU South Denver, until January 1st. Okay? Those of you that have been watching the videos and continue to watch the videos or need to watch the videos, at some point there was some confusion about how long those videos are available. They will be online until January 1st. So when you find that you really love tonight's lecture and you want to watch it again and again and again, you can only do so until January 1st. But you have until January 1st to get those all made up. So I just want to make sure everybody's clear on that. If you have any questions, I'm happy to talk with people at the end, or CU South Denver or recorded viewers, feel free to text or email me and I can answer you. The other thing I sent out, and I'm sorry I sent so many emails this week, but I sent out that information about the Court of Military Appeals that's going to be at the law school next Tuesday. If you want to come for that, you're more than welcome. We just ask people to register so that we have a good door list for the court's security team. The registration link was in what I sent you, and you'll be able to stay on through the evening into mini law school. Again, keep in mind the parking restrictions don't lift off our lots until 5 o'clock. So if you're going to come here early for the court, you need to park at the metered parking and then maybe move your car at 5 o'clock or whatever. You can figure out your logistics. So without further ado, Mark has been very patient with me, and I really appreciate that. So let's give him a warm welcome and hear about water law.
Thank you, Marcy, and it's great to be back here at the mini law school. So I'm going to spend the next hour and 15 minutes or so, maybe a little bit less than that, I hope a little less, talking about water law, and hopefully you'll have some questions that you'll be thinking about as we go through the material. I've also indicated my email address on the opening and closing slides. If you have questions that we don't get to, feel free to email me. I'll try to get back to you as promptly as I can. All right, so let me just tell you what I'd like to do tonight. I want to cover 4 basic things. I want to talk about the problem, the difficulty of managing water resources sort of generally. And then I want to shift to the evolution of water law, and I'm going to focus in particular on the Western United States, but I'm going to try to cover this more nationally than just locally. I'll then spend a little bit of time talking about the federal role in water management and water law, and then finally I'll close with a few thoughts about some hot topics today in water law. All right, so let's go to managing water. Well, no surprise here, it's complicated. Why is it so complicated to manage water? Well, it's not like other natural resources. It's not like oil and gas or timber or minerals that are fixed in place and that you can kind of predict in terms of what's going to be where and when at any given time. Water, of course, we know it's a seasonal kind of resource. It's ubiquitous. It's everywhere. But how much water we have in any given cycle is highly dependent on weather and climate and things that we cannot predict with any accuracy. So the challenge of managing this resource is because it's constantly changing, and we now have climate change issues that are sort of exacerbating some of the conditions and concerns that we have. Another problem that we have with managing water is that so much of our water is really not usable for reasons that I'll show you in the next slide. And we're partly responsible for that, although as you'll see, the big part of the problem really doesn't relate to human kinds of impacts. We're going to also talk today, as I mentioned, about our legal system. And I think it's fair to say that our legal system for managing water, while it varies over jurisdictions, is not very efficient or effective in managing water. You often hear, and you will read lots of articles about the water crisis that we face globally and here in the United States. But I would suggest to you that it is not a water crisis, it's a management crisis. We have enough water, we just don't do a very good job managing it. So I want to talk about how we might do better in some of those issues as we go through the slides tonight. Okay, so first, I want to just talk about water resources generally to give you kind of a sense for what we're dealing with. So if you look at the cylinder on the left-hand side of the screen, you'll see that the vast majority of our water resources are in the form of salt water. So they're not usable for the normal things that we need water for, at least not for a human consumption and use. You can see that only 2.5% of our water resources are in the form of freshwater resources. And then if you look on the right pie-shaped diagram on the right side of the slide, you will see that that 2.5% is not all usable fresh water. Indeed, almost 70% of that water is tied up in our glaciers and permanent snow cover. Again, not usable in any real sense. Almost 30% of our freshwater resources are in groundwater, and much of that, frankly, is not economically accessible. So we could get to the water, but some of it is just too deep to be practically usable, and so we're left with just a tiny fraction, really, of our total water resources that is generally available, and that is in the form, of course, of freshwater rivers and lakes. Note, by the way, almost 1% of the fresh water that we have is in swamps and other kinds of unusable kinds of supplies. They're important. Soil moisture, swamps, other kinds of things, those are important for the ecological health of our planet, but they are not the kinds of water that we can use. 0.3% of all of our water, of the fresh water, 0.3% of the fresh water, not the whole pot of water, is in these rivers and lakes which we can use, okay? So it's a tiny fraction of the water. The other point that it's important to make about water resources is the importance of geography. You all know this, I'm sure, but it's worth sort of thinking about it and pointing it out, and I've got a few slides to help us sort of think about how water and geography is so important. So if you think about how water law evolved, and again, you may not know this specifically, but I bet you sort of can intuit this even without knowing it. In the eastern part of the United States, the states took a somewhat laissez-faire attitude toward water management and water law. There's plenty of water there. Indeed, the problem in many parts of the East was trying to get rid of the water. We drained swamps, what we would now call wetlands. We drained them and really destroyed the ecology of many parts of the eastern United States because of too much water. So there really weren't issues about managing water in terms of supply. It's a totally different picture in the western United States. There wasn't enough water to do the things we wanted to do in the West, and so we set about reclaiming the western United States. It's an interesting word that we use, reclaiming. We're talking about basically changing fundamentally the ecological condition of the land in the western United States. And we spent gobs of money, and still are to some extent, reclaiming the western United States. And we were only partially successful, not terribly successful, I would say, certainly in not reclaiming large swaths of the American West, although we certainly have made a dent in that. Part of the problem, of course, in the West was these seasonal supplies that I talked about earlier. So we know that we have these big dams and other kinds of resources, largely because we're trying to hold the water in for those times that we need it, particularly if you're getting near a coastal area and you're concerned about not having enough water resources. Think California. You want to try to capture that water before it goes into the ocean, and it's part of that 97.5% that you can no longer use, okay? A few pictures. So Hoover Dam, of course, just as an example of one of these massive structures that we humans built to try to capture our water. Hoover Dam, one of the largest, but not the largest dam in the western United States, built by the Bureau of Reclamation. Note, it's an interesting project. It was one of these New Deal projects. It came in under budget and early. It was built before it was actually due. We don't do that anymore, but it's a remarkable kind of project. A number of people died in the construction of the Hoover Dam, so there were some costs associated with building the Hoover Dam. But note, it's a massive structure, 4.5 million cubic yards of concrete. You could build a sidewalk around the Earth at the equator with that one big plug of concrete that we put in the Hoover Dam on the Colorado River. A massive, massive structure. That's what reclamation looks like writ large. Got a couple of other slides that shows pictures of the United States, and this, I think, illustrates the point I was trying to make about water and geography a moment ago. This wasn't in your packet, by the way. I added this late because a friend just gave this to me. But it's a really interesting slide because the darker green on the left side, of course, in the western United States, those are the lands that have less human modification. And it's so clear, I think, from this picture that the eastern United States and the western United States are fundamentally different in terms of the ability of humans to modify their environment. We did a pretty good job of modifying the eastern United States for better or worse. Some would say for worse because we did do a lot of damage to our ecology. And while we've done some damage in the West, and you can see, for example, in the Central Valley of California, where there's been a lot of modification, you can still see a lot of dark green areas that we really haven't been able to reclaim. A different picture of this, and I like this slide except for the fact that they put the 100th meridian in the wrong place. The 100th meridian is the way to think about the 100th meridian, which is the line we often talk about as dividing between the arid west and the more humid east. It is a line, it's a vertical line that is coincident with the eastern border of the Texas Panhandle. And you can see that this line on the map is a little bit east of the eastern border of the Texas Panhandle. So this is not actually the 100th meridian. But you get the idea. You can see the yellow and the darker reds and browns. Those are the areas that are getting much less than 20 inches of rainfall each year. Almost the entire eastern United States gets more than 20 inches of water per year, precipitation per year. And that's normally how we think about this division between western and eastern states. And we'll see, I may come back to this slide because we're going to see that the law really did evolve because of the different conditions in the east and the west. Here's another map that I think is somewhat tragic but also important when we're thinking about water and geography. So the quality of this map is not very good, but the information is really startling in many respects because what it shows us, what it tells us, is the percentage of lands within each of our states where the wetlands were lost. It's the percentage of loss of wetlands in each of the states. And it's fairly shocking, not terribly surprising. You can see even here in Colorado, we've lost 50% of our wetlands due to development of various kinds. You can see, though, that it's really the agricultural states that has suffered massively in terms of wetland loss. So you can look at states like Iowa, 89%, Illinois, 85%, Indiana, 87%, and of course, California on the West Coast, 91% of the wetlands have been lost in that state. We've had a policy in the United States of so-called no net loss of wetlands for a number of years now. It was introduced by the George H.W. Bush administration. It's been, I would say, a modest success. It certainly hasn't been fully successful. One of the reasons that it has not been terribly successful is that we often replace high-quality wetlands with lesser-quality wetlands, sometimes open water, and that becomes a problem. But we are at least beginning to recognize the importance of wetlands to our environment. They really are, they're sometimes described as the nurseries of life. The vast majority of the important biological resources in the world and in the United States spend a good part of their life in wetlands. We destroy our wetlands and we destroy our biodiversity. Okay, so let's turn a little bit now and talk about law. But before we can get to law, we need to think about water in terms of the hydrologic cycle. So let me take you back to your high school science class, and let's talk a little bit about what the hydrologic cycle looks like. Well, first of all, it's important to remember that surface and groundwater resources are interconnected. There are connections, and I'll show you some examples of how they're interconnected here in a minute. So we often think of surface and groundwater as being separate, and our law, to a large extent, continues to treat them as if they are separate sources of supply. But they're really not, and so our decision to treat them that way in the law can be problematic. I want to take a look, I guess, at the hydrologic cycle in diagram form here, just to remind you about these interconnections. And so you can see on the diagram that we have rainfall and precipitation and snow. It's infiltrating into the ground. It's forming rivers and streams. Note that a lot of it evaporates or evapotranspirates through vegetation. So it goes back to the atmosphere and comes back down. And note the connections. There's infiltration into groundwater and surface water. So there are these connections between the surface water that we're seeing and the groundwater. And I'm going to show you some additional examples of that. So water, we're not creating any more water. We're not losing any more water, except to the extent that we are perhaps making some of our water unusable through contamination. But the amount of water on the earth is constant. It's constant, and so that's not going to change. It may change in character or, as I said, usability, but it doesn't change itself. Okay, so let's shift to law now. And we're going to start with surface water law. As I said, one could treat water law as just being a unitary subject, and I'll have something to say about that. But we're going to have to divide our discussion into surface and groundwater law because in most states they are treated in this separate kind of way. So let's start with surface water law. So there are basically two different systems, actually three now. I want to talk about the Eastern Permit systems too. But as the country evolved, it really was two systems. And the dominant one in the Eastern United States is what we call the riparian rights doctrine. Riparian rights. And the idea, so the word riparian referring to people who have land along a river or stream, or we sometimes use the word littoral to talk about land along a lake. But the riparian doctrine is a very sort of limiting kind of water rights system. It basically says that all of the people who own land adjacent to natural water bodies have water rights. They have riparian water rights. So your right to water is dependent in a riparian jurisdiction on your ownership of riparian land. That's the deal. And they are correlative rights, which means that your rights are dependent on everyone else's rights along that same stream or lake system. You share with everybody else, okay? And I'll explain a little bit more about some of the problems with that correlative rights system and with the limitation of riparian rights being limited to people who own riparian land. Well, in the Western United States, the law evolved very differently. And the law evolved in part because of the law that developed in the mining camps. So you've all read stories about the mining camps. I'm sure you're somewhat familiar with how that worked. Miners would come out to the western part of the United States before we had states, when they were still territories, and they would look for valuable mineral deposits. They were trespassers to a large extent on federal lands, at least until 1866, when Congress passed a law essentially authorizing miners to come out and take minerals. But they were taking minerals, and the problem was there was really no law out west. There was no ability to sort of deal with the conflicts that were inevitably going to arise among miners who were trying to get these mineral rights to various tracts of land. The miners set up these mining camps in lots of places. We're familiar with those here in Colorado and in many other parts of the states. And the mining camps really set up their own system of laws to deal with how the allocation of mineral rights was going to take place. And what the mining camps had decided was that they would protect priorities. They would protect the first miners who staked out and located mining claims. And as long as they were diligently working those claims and working toward the development of those minerals, they would be protected against some later party who came in and tried to stake over those mining claims. And so that was sort of the early history of our mining law. And what the miners figured out was that they needed a lot of water to process the ores. And because of limited supplies and the seasonal cycles that I talked about earlier, they realized that there may not be enough water for all the miners to take water out of the streams to process their ores. And so they decided, why not apply the same law that we use for our minerals to water? Prior appropriation, first in time, first in right. Whoever gets the water first gets to use it before anybody else gets to use any water. So that's the first in time, first in right system. You are limited in prior appropriation states by a concept that we call beneficial use. Beneficial use, the definition is usually the basis, the measure, and the limit of the right. That's not very helpful in terms of knowing how much water you have. But the idea basically is you have to be putting that water to some reasonable use without wasting the water. It's a sort of an anti-waste notion. So you get to beneficially use, but if you are the first appropriator, you have priority, you get all your water before the next person in line gets a drop. Okay? So that's how the priority system works. It protects the people who are first in line. There's a third system that is a much more modern kind of evolutionary system, and it's a little hard to describe. I'll get to it in some detail here in a little bit, but the idea behind the Eastern permit systems is to try to take the best, I would say, from both systems, or at least to have a different way of thinking about water rights. And the main thing I want to say, and again, I'll come back to this, is that they've adopted some aspects of priority from the Western system, but in times of shortage, they actually provide for equitable sharing. So remember that under prior appropriation, the first appropriator got all the water before the next appropriator got anything. In Eastern permit states, typically, although they vary a lot, I should be careful because there are a lot of different versions of Eastern permit systems, but the idea is that you're going to share in times of shortage. That's an innovation, I would say, from both riparian doctrine and prior appropriation. So what's wrong with the riparian doctrine? Well, a lot of things, but let me just highlight three things that I think are highly problematic. First of all, water users lack certainty with riparian rights. So think about it again. There may be 100 people or more along a segment of a stream, and all of them have riparian rights. There may be land changes. There may be ways to subdivide some of those riparian tracts, so instead of one riparian owner, you're all of a sudden going to have 5 or 10 riparian owners along that stream, all of whom want their fair share of that river system, that water system. And the problem is that nobody can be sure that they're going to get water at any given point in time because they're all sharing equitably, but without any certainty whatsoever. So imagine 10 people along a riparian stream using water one day, and everybody's fine. There's enough water for all 10 of those users. But there's no more water than for those 10 users. The 11th and 12th and 13th user comes along, and they want their share. Everybody else has to adjust to accommodate the new users that are coming into the system. And then you can imagine how that spins out. Everybody wants their share. And one of the problems is that the only way to figure out who gets what is to go to court. I say on the slide it's reactive, not proactive. There's no proactive management system that helps us understand how much water each person has on a riparian system. Instead, you have to go to court and claim that somebody is using an unfair share of the water. And you have to have a court adjudicate that. Courts historically have not been particularly knowledgeable about water disputes, so sometimes we get interesting decisions from courts that may not track other decisions from other jurisdictions. The system is often problematic, the judicial opinions that we have. Another important limitation and problem with the riparian doctrine is that it limits riparian rights, or water rights, I should say, to riparian land. In fact, this is a really negative problem. One of the reasons that in the eastern United States we've lost most of our wetlands is because the people who get the water are the riparians, the people who have water along the streams. And those are often wetlands, as you might imagine. If you're close to a stream, you probably have water-saturated conditions on your land. You probably have drained that land to sort of reclaim it, if you will, to try to drain your swamp, if you will. And you're using that water maybe back on the land to grow crops. But there may be much more productive land upslope, away from the stream. And those people generally don't have water rights. There are ways, reforms to the traditional riparian doctrine that sometimes allow upslope users to, upland users to get water rights from riparians. But it's a very rigid kind of system that has not really accommodated the sort of kind of modern uses that we have. Cities often get water through condemnation and other kinds of things, but it's highly problematic. Okay, so that's riparian doctrine. What about prior appropriation? What's wrong with the prior appropriation doctrine? Well, the basic problem is that the first users are not necessarily the most efficient users. Indeed, they're often some of the least efficient users, and yet we are essentially guaranteeing their rights before anybody else gets any water. And the way this has worked out is largely to the benefit of agriculture. Now, I don't want to sound like I'm anti-agriculture. Obviously, agriculture provides a lot of important crops and things that we all need and use. But because of the water rights system that we have in states like Colorado, the vast majority of our water goes to irrigated agriculture. In Colorado, it's about 85%, probably a little bit more than that. Some people say close to 90% of our water resources go to irrigated agriculture. Much of it goes, frankly, for relatively low-value crops like alfalfa. People are making a lot of money growing crops like alfalfa, but they are not sort of essential crops to human welfare. And part of the reason that all this water is tied up in agriculture is because while there is a system that allows for reallocation of water, a water transfer process, so we could actually get cities like Denver to buy water from agricultural users, the process is badly broken. It's very difficult to move water from one type of use to another type of use because of what an economist would call transaction costs. What the rule is that if you're moving water from one use to another use, or even from one place to another place without changing the use, you have to show that no one else who's using water on that system would be injured by your move. And something as simple as a change in the timing of return flows to the stream. So think about it. We've got an agricultural user upstream, and that agricultural user is applying the water to her land, and that some of that water drains back into the stream, and it does so slowly, so it replenishes the stream maybe later in the season. That's a good thing for downstream users or farmers. If that person wants to sell her water right, let's say to a city, there are probably going to be 100 or more people complaining that she is injuring their water right. And if she's allowed to actually transfer that water, it's probably going to be a limited amount, and it's probably going to take years and years of litigation to figure out how much and when she gets to transfer the water. So if you're a city, you're looking at that and you're saying, it's not worth it. I don't know how much water I'm going to get. I'm going to be tied up in court for years. It's going to be controversial. It's not going to be any fun. I'm just going to go build another dam. And that historically has been the answer. that many of our cities have had to build infrastructure, engineering solutions, sometimes called, right, to deal with the problem because it's so difficult to reallocate water in the prior appropriation west. We could talk about this more. I've done a lot of writing on the subject of water transfers and what is sometimes referred to as water marketing. Okay, so let's move on to Eastern Permit Systems. Well, I don't have the what's wrong intro to this slide because I actually think that Eastern Permit Systems work pretty well, at least the best of them. So under an Eastern Permit System, typically you have to get a permit, as the provision sounds, for the water right. By the way, you generally need a permit in prior appropriation states as well. You don't need one in riparian states, but you generally need them in all these other jurisdictions. It's just that in an Eastern Permit System, your permit tends to be limited to a term of years. You get a permit for 20 years maybe under an Eastern Permit System. It is subject to renewal. You often have a presumption of being able to renew that right, but when the state renews your right, they can modify it in some fashion. Maybe after 20 years has passed, they've decided that you could operate more efficiently. So they're reviewing your permit and trying to update it and modernize it to deal with modern kinds of provisions. Note, under Eastern Permit Systems, you're no longer tied to riparian land. Doesn't matter what land you own. If you can put the water to some kind of reasonable use, then you're allowed to have a permit for the water if the water is available. Note, there's not sort of a strict priority system in the Eastern Permit Systems, but their priority is taken into account. Generally, you're not given a permit if the state thinks that there's no water available in that river system. So you're going to have to show that there's some water available, but if there's water available, you'll generally get the permit. And then if a shortage nonetheless occurs, as I mentioned earlier, there is a program generally for sharing equitably. So when times are tough, everybody kind of pulls together and shares the limited water supplies that are available there. Note, in many of these jurisdictions, they charge permit fees. That helps to run the program. The fees can be obviously built up to the point where they assure that the agency has sufficient resources to implement and monitor the program, make sure that people are not using any more water than they're entitled to use. And so that can be a good thing. And the public interest is an overriding consideration in Eastern Permit Systems. You generally cannot have a water right if it interferes with the public interest. Now I'm going to come back and talk about the public interest a little bit later in the presentation. Okay, so that's a real quick nutshell description of surface water law. Groundwater law is a lot more complicated than surface water law, and I'm just going to really scratch the surface of this, but let me kind of just sort of tell you sort of how this evolved and kind of where we are. So first of all, as I mentioned, one of the problems with our groundwater law is that we treat it as if it's a separate resource from surface water. And yet the two are interconnected to the point that if you pump a lot of water out of the ground, you're likely to affect some surface water system. I'll show you that connection here in a little bit. So if you have a legal system that treats your water, your groundwater, separately from your surface water, and some big groundwater pumper is affecting that surface water system, there's no way to deal with that conflict or that problem, at least not without sort of somehow fundamentally shifting your law. So that becomes sort of a problem. This evolved from a doctrine that we borrowed from England called the rule of capture. So the rule of capture was this idea way back probably in the 17th and 18th century in England that we didn't know what was going on underground. We knew we could stick a pipe in the ground and some water would come out. We had no idea why it was coming out or how we could pump it out of there, but it was nice, clean, fresh water, and by gosh, we were going to use it, and we didn't care what was going on underneath as long as we could get that water. And of course, in a country like England, which has a lot of groundwater fairly high up to close to the surface, it was very easy to get groundwater in that way. And the rule of capture basically said that you could take as much water for whatever reason you wanted without owing anything to anybody. You could put a pump in the ground and you could pump out that water, go for it, because it was thought to be a benefit to take that water out. And by the way, we had no idea what was going on down there anyway, so how would we possibly regulate or tell you what you could take? Now, of course, people were taking water from water that was underlying other people's lands, and as I said, from surface water systems, and I'll come back to that in a minute. Somewhat shockingly, we still have, I think, 3 states that continue to follow a rule of capture, at least in part, the biggest being Texas. And Texas has adopted some reforms in some parts of the state that are under real severe crisis, but in some parts of the state, you can put one of these big fat centrifugal pumps down there and pump water like crazy and not answer to anybody for it. You can dump it out on the ground, in fact, if you want, and you don't really have to answer for it. That's obviously a problem. I think Texas has begun to recognize this problem. They have been moving towards some reforms, but they're not really there yet. Okay, so one of the other things that happens with groundwater, and I'll try to explain this a little bit more in a bit here, is that if you start taking too much water out of the ground, you're going to potentially cause the surface of the land to collapse. So you've probably all heard about surface subsidence problems that have occurred in areas. The Texas Panhandle's one, southern Arizona's one, California, Southern California around the LA area. They've had serious problems with ground subsidence from pumping too much water out of the ground. We can talk about how that happens and why that happens if you're interested. I'm just going to leave it at that for now, but I will come back to this notion of groundwater mining here in a minute. All right, so I want to try to explain to you a little bit more about groundwater before I briefly try to give you an overview of the law. So this just gives you an introduction, I guess, to the groundwater system that we have. And you can see the stream here, and you can see the groundwater connected to the stream and the well that's pumping water to the surface of the ground. And note what that well has done. It's effectively changed the direction of flow of the groundwater. So the groundwater was flowing from left to right to the stream. That's what we would call a losing stream. And all that water was flowing into the stream. Now we put the pump there, and some of that water is coming out of the stream, and it's depleting the surface water system that we have there. So imagine if you have a bunch of prior appropriators, let's say, relying on the water that's in the stream, all of a sudden there's less water available to them. Okay, so this, for those who like science, stay tuned. For those who don't, you might want to take a quick cat nap. I'm going to talk a little bit about the science of groundwater, because I don't think you can understand groundwater law unless you understand hydrogeology and how water exists underground. So I want to just talk about 2 different types of aquifers, what I'm going to call confined aquifers and unconfined aquifers. And the unconfined aquifer is essentially a water table aquifer. So it's that water that's, closest to the surface. Typically, you put a well down and the water comes out if you pump it. You have to pump water from a water table aquifer to get it to the surface. Confined aquifers exist under pressure, and there's something we call the pressure surface or the potentiometric surface, okay? And I'll show you a few diagrams of what I mean by that as well. All right, so we're going to see that. But the problem in a confined aquifer, that's where you get artesian wells. You've all sort of had some exposure to artesian wells. You put a hole in the ground, and all of a sudden the water just comes right to the surface. No pumping is needed. The water just comes to the surface. That's because that water is under pressure underground. And it's under pressure because it's between 2 confining beds. That's a confined aquifer, okay? So I'm going to talk a little bit about this law, Darcy's law as well. My wife warned me not to tell you about Darcy's law, but I'm going to do it anyway. So pay attention here. Okay, so here's there's a lot going on in this diagram, but I want you to sort of look at it and pay attention. So you can see we've got a water table aquifer close to the surface, and you can see the well that's going into the water table aquifer. Look what happens to the water in the well. It rises to the level of the water table. So if you're putting a well into a water table aquifer, that's how high it will go. Note, by the way, you can see the direction of groundwater flow. you can't see this going on underground, right? We don't know exactly what's going on, but if we were to put a water table aquifer in that same water table up higher on the slope, the elevation of that water would be higher, right? Because we're at a higher elevation, and we would know that the groundwater is flowing down in that direction. We might suspect it because of the contour of the land, but note that that unconfined aquifer, that groundwater aquifer might be doing something different than the surface. It might be sloping down instead of up on the right-hand side of the screen, okay? All right, so below the groundwater aquifer, we have two confining beds, or aquitards, we sometimes call them. You can see these two confining beds, and they are squeezing the water in that confined aquifer. That water is under pressure. There are actually two elements of pressure, what we call elevation pressure and the other, elevation head and pressure head, two different kinds of factors that relate to how high that water is going to come to, or how quickly that water is going to come to the surface. But you can see if you drill a well into the confined aquifer, even though it is much deeper than that original confined aquifer, that water shoots up to the surface because it's existing underground under pressure. And you're releasing that pressure when it comes to the surface. Note, by the way, I don't have a lot of time to talk about this, but think about how the conflicts can arise in confined aquifers. So if you put lots of wells, everybody feels great about a confined aquifer at the beginning because everybody's getting that water without having to pump. And pumping water is really expensive. Water's heavy. If you can get that water to come to the surface without paying for it, without any electricity, wow, that's great. But of course what happens is if everybody starts putting their wells into the confined aquifer, the pressure goes down because everybody's releasing that pressure that's underground. And pretty soon the water levels drop. It's no longer coming to the surface. In fact, it's very deep now. You've got to pump from significant depths. And every additional well into that confined aquifer is going to reduce the pressure for everybody else. So you can see where the conflicts come in. The original well owner says, hey, wait a minute, I'm supposed to be getting this water for free without having to pump it. I was the first one here, and all of a sudden all these other people come around and they're causing conflicts with those original well owners in the confined aquifer. So that's sort of what's going on here. You can see, by the way, the other surface connections that are going on, the connections into that little stream and the confined aquifer feeding it. There's something up there called a perched water table. It's just showing that there's a confining bed that's holding water up at that high elevation. So sometimes in a high elevation mountain area, you're going to have a confined layer. It's going to be some kind of shale or clay often that isn't permeable, doesn't sort of transmit water very easily. And when the water seeps into the ground, it will hold it into a kind of high-level water table, and you can put a well into that perched water table, as it's called, and you can get water that way. Okay? All right, here's Darcy's law. Sorry. Again, I just want to sort of tell you about this. So because it's really sort of an important principle, and so even if you don't understand math or physics, I'm sure you can understand this because Darcy was this famous mathematician who hypothesized that he could tell you which way liquids were flowing. Liquids are, in fact, gases for that matter, by basically drilling two wells into the ground and looking at the different elevations of those wells. And so look at the diagram here, and you can see very simply what's going on. We're filling this cylinder from that reservoir that's up there. And note what that reservoir is doing. It's putting pressure on the water as it comes through that sand-filled container, which is our little aquifer here, right? And you can see the cylinder itself is the confining bed, right? So that water's coming through the sand-filled container, and if we tilted it, the diagram's not tilted, but if we tilted it, you would get a kind of elevation at it, and you could tilt it either direction, right? You could tilt it in either direction. And what would happen if you drill a well into two different parts of the container, you would see which direction the water's flowing. Now imagine you don't know about the reservoir, you don't know about any tilt, you just drilled 2 wells into the same aquifer, you would be able to know that water flows in the direction of decreasing head, or basically the decreasing elevation in those 2 wells. So we know, I mean, it's obvious because I've given you all the information on the slide, but even if we didn't know that there was a reservoir here, or even if we didn't know anything about a tilt to that cylinder, we could drill those 2 wells into the cylinder and we would know the direction of flow. Think how important that is, not just for water, for things like oil and gas and everything else that flows underground. If you can put a couple of wells in and figure out flow, you have lots of very useful information. So Darcy's law is very helpful in understanding how things are working underground. That mystery that Old England couldn't figure out, Darcy helped us sort of figure out what was going on underground. And if you think about things like contamination, this is really important information. If you're introducing, or there's some kind of water that's contaminated, you really want to know the direction of flow because you want to know where that contaminated water is going to go. And you want to sort of try to ameliorate the problem, and you can do that much better if you can understand the problem of groundwater flow. Okay, so I touched on this before, but let me just highlight it again for you. I want to talk about the problem of groundwater mining. We call the term mining to describe the phenomenon where you're taking more water out of the groundwater aquifer than is naturally recharging into that aquifer. So imagine that we've got, the easiest thing to imagine is a water table aquifer. So we know that water table aquifer is essentially formed from water that seeps into the ground from precipitation. Rainfall, snowmelt, runoff from various kinds of things. And it varies. We know our water tables vary. If you were all around during the September 2013 floods, we saw our water tables go up really dramatically and flood a lot of our basements and crawl spaces in our homes, right? But that was because the water table came up from all that precipitation that we had. That was the water table aquifer that was causing that particular problem, right? And so we know that those water tables are formed by recharge. If we start taking more water out of those aquifers than is being replenished, the water table is going to go down. The water table itself will just drop. And so our pumping costs are going to go up. If a lot of people are taking water out of that aquifer, it's going to go up. Note, if you're taking a lot of water out of that confined aquifer, so let's go back to our confined aquifer now. That confined aquifer is down there underground between 2 confining beds, 2 layers of clay or shale or some kind of medium that is holding that water in between those 2 confining beds, those 2 aquitards, right? And you start drilling a lot of wells into that, and all of a sudden you're depleting the water that's in there. Now that aquifer is made up of things like sand and gravel and other things that transmit the water very easily. That's why when you put a pump down there, it's real easy to get that water to come to the surface. But if you start taking too much water out of that confining bed, then all that loose gravel, think of a glass of water that you might fill with sand or gravel. You can, when you fill that glass up, the level of the sand and gravel is going to sort of bump up a little bit because that water is going to cause it to sort of expand or float. You can try it and experiment at home. Just try to put all that water in there and see it come up. When you take the water out, that sand and gravel collapses. Now imagine a sand and gravel deposit that maybe is 200 or 300 feet thick. And you've pumped a lot of water out of it so that now it starts to collapse, right? That's what causes surface subsidence. Now it's somewhat dependent on the geology. It doesn't happen everywhere. But in lots of places, if you engage in groundwater mining, taking more water out of that aquifer than is being recharged on a regular basis, you're going to see that aquifer collapse. And of course, once it collapses, the capacity of that aquifer to hold as much water is going to be reduced, maybe substantially over time. So we've seen a lot of examples around the globe and in this country of groundwater mining leading to subsidence of the surface and destruction of the storage capacity of the aquifer. Okay, so here's just sort of an example of sort of groundwater mining and more importantly, groundwater conflicts, I guess. So these are fairly commonplace where there's a lot of groundwater pumping. And the conflicts really became much more pronounced. I think it was around the 1920s that the centrifugal pump was developed, which is a high-capacity pump that allows you to take a lot of water out of the ground. They're used primarily in agriculture because of all the water they need to be irrigating lands. You've all seen the pivot sprinklers around the state, and if you fly in an airplane, you can see the circles that are made by the pivot sprinklers. Those are typically being used with a centrifugal pump that is pulling a lot of water out of the ground to provide the water for irrigation. And you can see the big pump here taking a lot of water, and note what it does. It creates what we call a cone of depression in that aquifer. It basically causes, and the cone might be in terms of the pressure. We can illustrate this through pressure reductions. We can illustrate this through groundwater losses. But what you can see that cone of depression does is it causes conflicts with shallower wells. And of course, these conflicts tend to be fairly serious, so just sort of visualize what's going on. Maybe in some rural areas, a lot of people rely on a well for their water. They may have been relying on that well for years and years, and there never was a problem. And all of a sudden, a neighbor, maybe a neighbor that's 2 or 3 miles away or more, starts pumping water at a significant rate out of one of these high-capacity wells, and with a high-capacity pump, and the water level goes down, the cone of depression develops in that area, and after a couple of years of pumping, you can see that these shallow wells of residential users are going to lose their water. The water's gone. The well goes dry. Okay, that's the conflict that typically happens. Okay? All right, so that leads to my discussion of law. So here's everything you need to know about groundwater law in one slide. I won't be able to talk about this in a lot of detail, but let me just try to explain what's going on. So first of all, it's really kind of neat and easy to talk about surface water law because you can kind of divide the states up between the states that are east of the 100th meridian and the states that are west of the 100th meridian. The states that are east of the 100th meridian basically are riparian states. The states west of the 100th meridian are pretty much exclusively prior appropriation states, and now some of the eastern states have adopted the sort of modern permit system. That's kind of how it breaks down. It's very straightforward. Not so much with groundwater law. The laws are all over the place, and a state like Colorado has multiple different laws that apply depending on where you are. Colorado has what I would guess are the most confusing groundwater laws of any state in the country. I'm just going to describe them briefly in a moment here. But let's look at the 5 basic different rules that apply to groundwater extraction. And so we'll start with the first, which I've already touched upon. We sometimes call it the English rule or the absolute ownership rule. Note it is that rule of capture, and there's no limit on where you have to use that water. So you maybe have a tiny parcel of land, you put a well on it, and you put a big fat capacity pump on that land, and you start pumping water and selling it everywhere you can sell it. And there's nobody that can stop you, no limit on the place of use. Strictly rule of capture. If you can get it, you own it, and go for it. Obviously not a very good rule for trying to make sure that everybody gets their fair share of water, but as I said, it actually still applies, at least in parts of a number of jurisdictions. I think the 3 that I'm aware of are Indiana, Maine, and Texas. Okay, there's another rule, somewhat like the English rule, called the American rule, and the American reasonable use rule, sometimes it's described, and it's actually not a whole lot better than the English rule, because like the English rule, it's a rule of capture. The only difference is that you're limited to reasonable uses, and you're generally limited to using it on the tract of land from which you extracted it. So I guess those are 2 big differences. But the problem is that once you satisfy those 2 criteria, you can take as much water as you want, and it doesn't matter whether you're taking more than your fair share of the water. So you've got a parcel of land, maybe you have some kind of water-intensive activity that you're engaged in on that parcel of land, you can take as much water as you want. Doesn't matter how you're harming your neighbors or anybody else. That's the reasonable use rule. That was kind of a modification, as you can see, of the English rule. And then we have what we call the restatement rule. So the restatements of the law were basically the series of legal documents that were prepared by experts to try to sort of explain what the law is or should be in a number of different areas. And there's one on property, basically, and this one actually is on torts. So this is the restatement of torts, section 858, and it basically adopts a principle of shared use. It's sort of like the riparian doctrine because everybody has to share in an equal way, but it has some, I guess, some advantages over riparian doctrine. Most importantly, you're not limited on where you can use the water. You can use it anywhere as long as you're not taking more than a reasonable share, you're not causing unreasonable harm to other users on the system, and if other people want to use it, you have to share, basically. So it's a little more modified doctrine that allows sharing. And like the surface water law, we also have a prior appropriation doctrine that applies in some jurisdictions. So some states like Wyoming, New Mexico, Utah, they follow a pretty much pure prior appropriation doctrine for both their surface and groundwater law. It's not a unitary system, so they treat them separately, but they still deal with priorities. So the first person to take that water has priority over everybody else. You can use it anywhere you want, but there's a caveat here because groundwater and surface water have these fundamental differences. Even though they're connected, they do have these fundamental differences, most notably that you can cause these conflicts between among groundwater users. We saw the wells going dry. We saw other kinds of issues that arise from subsurface subsidence and that kind of thing. And so in the priority system for groundwater, we basically have this notion that you have to maximize the beneficial use. And that sort of tells people that well owners who have a shallow well that is not of a reasonable depth may have to deepen their well so that everybody can get water out of that water system, right? So that would be one sort of difference between a pure priority system and the groundwater priority system that we have there. Other kind of conflicts might be resolved in the same way. So the priority system is pretty much like the surface water priority system with a few modifications to recognize that conflicts with groundwater use are much more complicated. Okay, and then finally there's the correlative rights doctrine. California is the primary state that has followed correlative rights in most places. They've recently had some statutory reforms in California. The correlative rights doctrine is probably the closest thing we have to the riparian system for groundwater because it's a shared water rights system. Sort of like riparian doctrine, you're limited to using the water on the tract of land where you took it from. So it's sort of what we call an on-tract kind of limitation. And you can sometimes take it off the tract as long as everybody on tract gets the water that they want. But in times of shortage, you have to share, just like under the riparian system. So you're not sure ever what you're getting, but you know, if somebody else wants to use water and they're a surface owner overlying some groundwater, then they get to take water out and share it. So those are the basic 5 groundwater rules that apply throughout the United States. Here in Colorado, as I said, it's kind of a mess. The good news, I would say, to start with, is that most of our groundwater is what the state calls tributary groundwater. What's tributary groundwater? Well, the idea is that any water that would essentially make it to a stream over a certain period of time is likely to be surface water, and we're going to manage it and regulate it as part of our surface water system. And the sort of definition is quite extreme. If 0.1% of the water that you're taking out of a well after 100 years of pumping would come from a surface system, it's tributary groundwater. Just try to visualize this. First of all, who knows what would happen in 100 years because nobody's been pumping that long. But just try to visualize what the definition means. stick a pump in the ground, maybe 5 miles from the nearest surface water system, and start pumping, presumably at a constant rate, although your rate may change, but let's just take it at a constant rate. You're pumping for 100 years, and the question is whether 0.1% of that water you're getting out of the ground came from that surface water system that was 5 miles away. Who knows? Partly because we don't know what would happen after 100 years. But the point is that that's a very broad definition of water, of surface water, basically. So when we use the phrase tributary groundwater, think surface water, because that water is being managed as part of the surface water supply. But that was not, unfortunately, enough for Colorado, because particularly here on the Front Range, and particularly around Denver, some of the aquifers there, it was too complicated to apply the tributary groundwater definition. And so we have other terms that we use, and in particular in the Denver basins, we talk about not non-tributary groundwater. So we have tributary groundwater, which meets that definition I mentioned. We have non-tributary groundwater, which doesn't. And then they set up this other category of not non-tributary groundwater. And so you say, well, isn't that tributary water? And the answer is no. That's a special category of water that technically meets the definition of tributary water, but that is managed in a different way. And so that's why Colorado law is so darn confusing. It's very difficult to sort of sort it out. We have a couple good things in our law. If you're depleting, let's say you're pumping water out and maybe 1% of that water is coming from a surface water system, and yet you're doing something really valuable with that water, you have the right to replace that water you're taking from the surface water system, just that 1%, and continue to pump. We call that a plan of augmentation. You have to file it, but it's a way for you to get around that tiny percentage that you're taking out of the surface water system. We can talk about that more if you're interested. And one other interesting case I thought I'd mention about groundwater has to do with oil and gas development. There's a case from a few years ago from the Colorado Supreme Court that said when you take water out of the ground to produce oil and gas, so some of you may know if you're producing oil and gas out of the ground, you sometimes have to take water out first, particularly with a coal bed methane well, because often that methane is held in by water. So you got to pump the water out to get the methane out. What do you do with that water? Well, the farmers who were near these coal bed methane fields, they were complaining that their wells were going dry because of all this water that the oil and gas users were pumping. And so they sued the state engineer for not requiring permits. State engineer is one of the chief water officials here, but they sued to basically require that these oil and gas well developers get a water permit. And the oil and gas developer says, no, we don't need a water permit. We don't want that water. We're just trying to get rid of it. We want the oil and gas. We're not putting that water to a beneficial use. The Supreme Court disagreed with them and said, no, if you're going to take that water out, the beneficial use is the ability to get the gas out of the ground. You've got to get a permit, and you've got to work with us to make sure that you're doing it in a proper way, consistent with our laws. So all the oil and gas permittees have to get permits for the water that they're taking out of the ground to develop their oil and gas as a result of that decision. Okay, that's sort of a real quick tour through a lot of the legal stuff that I wanted to cover, but let me shift gears a little bit, and I want to think about what this sort of idea of water really is. And we think about water as property, and it's what we might call a common pool resource, that it's a shared resource, whether or not you have a legal regime that recognizes that sharing. In fact, it is. We know that all of our states that have positive law on water basically treat that water as the property of the state. I'll show you Colorado's constitution here in a minute. But they all treat it as state property. Then what does a person get when they get a prior appropriation right? They get a right to use that water. It's what we call a usufruct or a usufructuary right. It is not a right to the water itself, or it's not a right at least to the property element of the water. That is held by the state. You get to use it, and using water is a property right, just like an easement is kind of a use right where you have a property right, but it's not title to the water itself, okay? so you can get that vested right. Note, virtually every state, Colorado being the only exception, also require that water resources be managed to protect the public interest. I'll touch on this here in a minute. But Colorado is really the exception to every state that has what we call positive law or statutory law. Every other state recognizes public interest protections. I'll talk about that here as we go. Okay, so if water is property, and it is, even though it's just a use kind of property right, can a state that historically has been a riparian state shift to a permit system? Remember that you had this right to use water as a riparian. Can the state come along one day and say, we're going to require a permit from here on out, and in order to continue to use water, you need to get a permit? The answer is probably yes. The state of Oklahoma, the Oklahoma Supreme Court, has suggested otherwise, but virtually every other state that has considered the question has allowed states to shift their system. Remember that just because the state shifts to a permit doesn't mean you're not going to get water. It doesn't mean you're going to be deprived of your water. It just means you're going to have to apply for a permit to get that water, and most courts would say that is not a violation of the Constitution, something called the Takings Clause of the Constitution. It's a little bit more problematic in a prior appropriation state, mainly because of sort of the historical way in which our prior appropriation doctrine arose. People who own water rights think of them as sacrosanct, that nobody can touch them. And if we were to try in the state of Colorado, for example, to shift our permit system, we have a permit system now, but it's permanent. If we were to try to shift that permanent permit system to a permit system for a term of years, I think that would be constitutional. I think the state could do it. I think politically, though, it would be almost impossible because of the sort of way in which water rights holders in particular view their property rights, their rights to that water. So we might be able to do it. There are good reasons to do it, because what we've learned from the eastern permit states is that revisiting these permits from every once in a while or every 20 years or so helps us to protect public values in the water that are sometimes lost because of bad decisions in the past. But again, it's a big lift in a state like Colorado, or really in any of the western states. Here's the Colorado Constitution, by the way. It talks about water rights in Colorado. You can see the water of every natural stream not heretofore appropriated within the state of Colorado is hereby declared to be the property of the public, and the same is dedicated to the use of the people of the state, subject to appropriation as hereinafter provided. So we basically protect the right of appropriation, but it's state property, and it's dedicated to our use. Dedicated to our use. We don't really pay attention to that, to my mind. Let's just take a look at this. So here's the public interest, and as I said, every western state, every state actually that has positive law, that has statutory law, protects the public interest explicitly in their laws. And you could argue that that provision I just read to you is a kind of public interest provision, right? It's dedicated to the use of the people. Okay. But the Colorado Supreme Court has said, no, unless the legislature tells us otherwise, we're not going to protect the public interest in water in Colorado. So the legislature might still be able to do something, but not without, the court's not going to do it on its own based on the constitutional language. So other states do have this public interest standard, but it has not been, I guess, very well developed in many states. A few states have definitions. A few states do a pretty good job of protecting the public interest. I'll talk about that in a minute. But many states don't do much with the public interest standard at all. It's just in their law, and they really ignore it. Some states used to say that appropriating water for private use was in the public interest, and that was as far as it got. No, today when we're concerned about ecological values, recreational values in water, stream ecology, and various other kinds of public uses, that seems a little short-sighted, but that's sort of how this law evolved. We have another doctrine we call the public trust doctrine, which is somewhat related. The notion of the public trust doctrine is that when the state owns a property resource and they own that resource on behalf of the people, they have a trust responsibility. They have a responsibility to protect the people who are the beneficiaries of the trust. We, the public, are the beneficiaries of the trust that the state has. Colorado has never recognized the public trust doctrine in the state, and many of the water leaders are opposed to it, but a few states have and have explicitly applied it to limit water rights, California being the most notable example of recognizing a public trust doctrine that protects the public interest in the water, the public rights in the water, as against private users of the water. It's a difficult issue. Note the notion of the public trust doctrine in water goes back to ancient Roman times. The Institutes of Justinian was the sort of famous Roman code that talked about the following things being common to all: the air, the running water, and the sea. That's from a book called the Book of Things, and it's been well accepted really since that time. There's language in the Magna Carta and other kinds of historical documents that talk about the responsibility of the state to protect certain resources that are held in common for the public. Private people get to use those rights, but they're supposed to be protected by the public. We've not seen a whole lot of activity in the sort of Intermountain West on the public trust doctrine. And so, which sort of takes us to another aspect of this, in-stream flows. You may be aware that we protect a lot of in-stream flows in the state, but there's an argument that these should be protected under the public interest or the public trust doctrine. So sort of imagine that the state were to get an application for a water right. The state might say, well, before I give you this water right, I want to be sure that the public interest in water, remember this water is the property of the state, dedicated to the use of the people. I want to be sure that the people's right in that water is protected before I give you your water right. So you can have your water right, but you've got to maintain minimum stream flows to protect the public interest. 2 states do that, Washington and California, at least some fashion of that. But most other states like Colorado require the public to stand in line with every other prior appropriator. So the public in Colorado essentially has to acquire the rights. They're held by the state for the people, but you have to stand in line with other appropriators, and many of our in-stream flow rights are what we would call junior rights. That is, they don't have a very high priority date because they were acquired very late in the system. And remember, we protect first users first. So that's an issue with the in-stream flow protection. Let me just briefly turn to federal water law, and I want to try to wrap this up in a few minutes. So water is an article of commerce. The Supreme Court has told us that. And what that means is that the federal government has sort of plenary authority over water. If the federal government wanted to take over water allocation law in the United States, it could do that probably because of its commerce authority. But obviously for political reasons, it doesn't do that. It does exercise broad authority, though, over many aspects of water. So if you want to build a dam on a navigable stream, you want to take down a dam on a navigable stream, you got to get a permit from the federal government, probably multiple permits from the federal government. You want to put a hydro plant on that dam, you got to get a different kind of permit to build that hydro dam. It's a federal permit from the Federal Energy Regulatory Commission. You want to put pollutants into waters, at least navigable waters, then you've got to get a permit from under the Clean Water Act. It usually comes from the state, but it's under a federal program for regulating water pollution. Navigation, you want to build an obstruction to navigation, can't do it without a permit from the federal government. So we have a lot of federal regulation of waterways, different aspects of waterways. It's mainly just water allocation law that is left to the states, and that's by political design. It's not because it's required, but it's one thing that we do. Okay, so what's the division of power between state and federal government? Well, states can't discriminate against other states. So let's suppose the state of Colorado gets an application for a water right from a resident in Nebraska. They have to apply the same standards that they would apply in the state of Colorado to a water applicant. So they can't discriminate against other states. Note that the federal government really has to resolve interstate disputes. A lot of our major water systems flow interstate. And if one state, what we call the headwater state or the upstream state, were to build a dam at the border and hold all the water in for itself, that would obviously create interstate conflicts. And so the federal government, usually the U.S. Supreme Court, handles cases that involve those kinds of disputes. There are certain federal rights associated with federal reserves. I'll talk about that here in a minute. As I mentioned, navigation and obstructions to navigation and pollution discharges are all federally regulated as well. A lot of controversy over pollution discharges, 3 Supreme Court cases that have limited the federal government's authority. We sometimes talk about the WOTUS rule. Anybody know what the WOTUS rule is? So WOTUS stands for Waters of the United States. You've heard of POTUS, the President of the United States, and SCOTUS, the Supreme Court of the United States. WOTUS is the Waters of the United States, and it's sort of this famous rule that has been banging around for quite a number of years now. It's in the courts. It's probably going up to the Supreme Court. We'll probably get another decision on federal authority here. So I mentioned in the last slide federal reserved rights. There are federal rights in any federal reservation of land that needs water to fulfill its purpose. And so try to visualize the easy things to think about are maybe national parks, wild and scenic rivers, wildlife refuges. These all probably require some water to fulfill their purposes. And what the reserved rights doctrine tells us is that the reservation gets enough water to fulfill the purposes of the reservation and no more. Now, where this has been most controversial is with respect to Indian reservations. And that's partly because when Indian reservations were set aside, many in the middle part of the 19th century, they were set aside to change Indian tribes from a nomadic sort of lifestyle to an agricultural or agrarian kind of lifestyle. They had to farm and irrigate. And oftentimes there was not enough money to develop irrigation systems on these reservations. They were often very arid lands. But what the Supreme Court told us in a case from 1908 called Winters versus United States is that when the government set aside lands for an Indian reservation, it implicitly reserved sufficient water to carry out the purposes of the reservation. And if that purpose was to change the tribes from a nomadic lifestyle to an agrarian lifestyle, they got enough water to irrigate all the practicably irrigable lands in that jurisdiction. Turns out it's a lot of water, and they get a priority date as of the date of the reservation, often in the 1850s or 1860s, and so they jump priority on just about everybody. The reason why the reserved water rights doctrine is so controversial in the context of Indian rights is because it's a lot of water with an early priority date, and most of it has never been used. So for the other reservations, like a national park, the reason the park is there is because the water is still there and it's available. It's not so much a problem. What happens with Indian reservations, if all of a sudden an Indian reservation can develop a massive amount of water to irrigate its lands, it's going to interfere with lots of other water uses along that stream system. So the Indian reserved rights doctrine has been particularly controversial, and it's going to be interesting to see how that plays out going forward. Okay. Hot topics, almost last slide. So just wanted to sort of focus on some of the hot issues that are here. We can talk about these if you want. I mentioned water transfers. Conjunctive management is this idea of managing our surface and groundwater rights together. Restoring the public interest, we talked about that a little bit. It has a long ways to go in most jurisdictions, and we could do a lot more with it. Managing our water across jurisdictions, transboundary, trans-state, and international. Obviously dealing with climate change and its impact on water supplies. I want to leave you with this thought about the Colorado River, and it sort of is an example of the kinds of problems we're confronting right now. This is a diagram or a graph that was prepared by the Bureau of Reclamation in 2012, and it shows what's happened with our water supply and our water demand on the Colorado River. And you can see that supply is the blue line, demand is the red line, the line's crossed, which means that we are now using more water. The demand is higher than what the supply is, and the trends are not good. You can see projected demand on the right and supply. The trends are not very good. We don't know what's going to happen, primarily because of climate change. It's a really serious kind of problem that we're confronting, and so that's something that we're all paying a lot of attention to. These are slides I pulled off a website just a couple of days ago, and they show you where the big reservoirs on the Colorado River are today, or a couple of days ago, and you can see Lake Powell, as of a couple of days ago, was at 52% capacity, Lake Mead at 37%, a little over 37% capacity. And if Lake Mead stays below 1075, this first line here, if it stays below that, it's a little bit above it right now, but if it goes below that as of January 1st of this year, something called the shortage sharing agreement is going to kick in, and it's going to create lots of havoc, particularly in what we call the lower basin states, California, Arizona, and Nevada, because they're going to have to basically deal with a significant shortage of water. We don't know what's going to happen. They regulate those two reservoirs so they can provide supplies. We can maybe get by for another year or two, but the shortage is coming. We're going to have to deal with that sometime soon. Okay, that's all I've got, but I'm happy to stick around as long as you want me to try to answer some of your questions. Thank you. Yes? Money runs uphill to water is the kind of the expression that we talk about. Well, there's no doubt that money plays a big role in water, but I think it's probably less true today than it maybe was historically, because frankly, there's no water left to get. We sometimes talk about the water rights system now being, we've sort of gone from a system of allocation of water rights to a system of reallocation of water rights. That is, there's no water left in the system for people to get big new water rights. Colorado still thinks that there might be. Colorado claims they still have more Colorado River water that they should be allowed to take. But I just showed you the slide that showed that demand and supply curves have crossed. There isn't any more water in the Colorado River system. Now, reallocation is still on the table. And there are a lot of interesting things we could talk about regarding water marketing and ways to free up the free market to make water available in different kinds of places. That's going to take some, frankly, legislative reforms more than money. But I think that there are certainly prospects there. I don't doubt that money can still play a role in who gets the water and how much water they get. But I think it's probably less true today just because the opportunity to develop, we call it developing water, reclaiming and developing water. So developing water is basically building a big dam and storing the water behind it. You may know Denver Water has a proposal to expand the Gross Reservoir substantially for more water. They're probably going to be sued over that. I don't know if it'll ever be built. Northern Colorado Water Conservancy District has a proposal to build a big dam called the Windy Gap Firming Project up on the other side. Both of those projects are taking more water out of the Colorado River. I just showed you there's no water in the Colorado River. I don't know where the water is going to come from. So, yes, you can spend a lot of money building new water projects. There may not be any water to put in your new reservoirs. So it's a cautionary tale, I guess. I'm sorry, I'm supposed to defer to you, Marcy. Go ahead. Yeah. Forgot. How could I forget? Yes.
Hi. I've always been curious about the rules and laws around private residential rainwater capture.
Oh, yeah, I'm glad you brought that up, yeah. So until very recently, most people thought, I should say, it was illegal to capture water in a rain barrel in Colorado. I always thought that probably wasn't true. I would argue with lots of people in the water system. And the reason was that because of this, remember this notion of tributary groundwater and something we call tributary seepage, it's sort of like that. So the idea was if a water fell off your roof and was headed to a stream, it was tributary to that stream, and by gosh, you couldn't capture it. It was part of the surface water system, and you couldn't capture it in a rain barrel. I always thought that was ridiculous, and I thought that, let somebody sue me if I want to capture a barrel of water off of my roof. It's just not worth it to try to enforce that. I think the legislature finally figured out that was a silly restriction, and even the water rights community realized that they weren't saving a whole lot of water. And so as of fairly recently, we're allowed to have rain barrels now, and I expect we're going to see some local communities, maybe Boulder will be one of them, that starts promoting these rain barrels for water use.
Yes, I just wanted to ask if you could elaborate a little more about some of the concerns that people have in Colorado about water's private property rights or anything like that? Vis-a-vis, I would assume it's because they see California and they think, oh no, we're going to lose. They see it, what they feel is a disaster out there. So I don't know if you could just say a few more things about what some of those concerns are.
Yeah, well, I mean, that's a really complicated subject. There are a lot of aspects of property, water as property that we could talk about. But I think what the water users believe is that even though they only have a use right, it's a vested use right. And if anybody interferes with that vested use right, they have to be paid compensation under a provision of our Constitution called the Takings Clause that prohibits the taking of private property for a public use without just compensation. And so they have a very sort of, I guess I would say, rigid view of water as property, and they don't want anybody doing anything with their water as property without at least paying for it. And that really constrains the ability of states to manage water in a way that might be more flexible and might provide better kinds of water uses. I think it's a reality, and so I've been doing a lot of work on water marketing kinds of issues and trying to work within that reality to figure out ways that those farmers could save water. And that gives you a real simple example. There are lots of them. Supposing a farmer were to switch from alfalfa to sorghum. Sorghum uses about a third of the water that alfalfa uses over the life of the crop. So you could save 2/3 of the water by switching crops. But under our current law, you couldn't sell the water that you saved. I want to try to, and moreover, if you tried, even if you were allowed to sell it, you'd have to go through that elaborate transfer process that would take years and years and years and cost thousands of dollars, and it just wouldn't be worth it. So what I want to try to do is figure out a system where we can do a very efficient and quick transfer, at least of annual water rights. So you could transfer the amount that you saved this year. We'll have the state engineer or some expert say, okay, if you switch to sorghum, here's how much water I think you're going to get out of it. I'm going to discount that by 10% just to provide a cushion, and then you can sell the rest of that water. And you can sell it just on a temporary basis, just this year when you've decided to switch crops. Now imagine what that would do to free up water, particularly in a drought situation. So you were kind of hinting at the problems that we had in California and the potential for a drought. If it's a drought year and I can get really high dollar by switching to a lower consumption crop, I've got this huge incentive to do it because the cities are willing to pay top dollar for me to switch my crops. But under our current law, you can't do it because of that. Remember that no injury rule I talked about? And in order to actually have the transaction go forward, you have to go to water court in Colorado. It's a really cumbersome, complicated process. You have to hire lawyers on both sides. You have to hire experts. You'd never get it done. So we've got to figure out a way. In Australia, they can do what they call temporary water transfers for an annual water right. They do it in less than 5 days. They do a permanent transfer in 20 days. It takes years for us to do it here, and it takes so long, and it's so expensive, and you don't know what you're going to get out of it, that people are discouraged from doing it at all. And so remember, I gave you that statistic that 85 to 90% of our water is used by irrigated agriculture. You know, there's a lot of ways we could free up a lot of that water, but the incentive structure is all, even the farmers, I think, would welcome some of these kinds of changes. But the incentive structure is all screwed up in terms of getting that water to people that need it, particularly in the years when we really need it and where it would command a really high price. It's kind of crazy that we do it that way.
We've got about 2 minutes and we're straight at the back.
Okay?
I heard an old, well, he's not old, but he was a prior head of the Bureau
The Bureau of Reclamation?
Yeah, who wrote a book, Deadbeat Dams, and I heard him interviewed. And I didn't read the whole book, but basically he thinks we should get rid of our dams. And I'm wondering, what would the impact be from the law standpoint?
Well, I mean, so, you know, the whole policy regarding dams and dam removal is very complicated. There are some really interesting videos that have been done on the removal of the Elwha Dam in Washington State. So there have been a few fairly large dams that have been removed, but it's extremely expensive, And it's got to be managed very carefully because, you know, when you build a dam and that dam is around for 40, 50, 100 years, what happens is that the stream comes down, the water gets settled, goes into the reservoir behind the dam, and all the sediment that was in that water settles out to the bottom. And imagine how much sediment that is over 50 or 100 years. We've had some cases where the reservoirs have filled up with sediment because of all the sediment. So imagine, just to give sort of the most extreme example I can come up with here, the Colorado River and the Glen Canyon Dam. A lot of people want to take the Glen Canyon Dam out because it, you know, monkey wrench gang and all that stuff, if you've read the books about that particular dam. It was a very controversial dam when it was built, but there is a massive load of sediment behind the Glen Canyon Dam. And taking that plug of concrete out is going to, first of all, it's going to cause some pretty severe ecological damage in the short term. The experience suggests that the rivers recover reasonably quickly from these, but we've never done one the size of Glen Canyon, so I don't know what would happen. So I think that we are moving in the direction of dam removal. There have been recent studies you may have seen that dams with big reservoirs actually release more methane into the atmosphere than coal power plants do. So there's a lot of climate concern now about dams and reservoirs, and people are kind of scratching their head because they thought that hydropower was the answer to one of the problems, I guess one of the solutions to the greenhouse gas problem that we have, and it turns out maybe not. And so dam removal is getting a lot more attention. We're seeing it in some minimal, isolated kinds of cases, some reasonably sized dams. Removing the really big ones is going to be difficult. And it'll be interesting to see if it ever happens. I mean, you know, the interesting thing about Glen Canyon and Lake Mead is that it probably doesn't make sense in the long term to have two big dams like that because both of them are at such low capacity right now. If that's the history, if that's what it is going forward, we'd be better off with just one big reservoir and one dam, and we wouldn't lose as much water to evaporation and to seepage. Interesting.
So I think my favorite thing about mini law school is it gives us an opportunity to show you the caliber of professors we have and how very much they care about the subjects they teach and what a great job they do teaching it. And you're such a terrific example of that.
Thank you,
so
Marcy.
much.
I appreciate it. Thanks, everybody.
And we'll see everybody back next week for the final week. Have a good week.
All right.